Hello guys, thank you for joining to our panel today. My name is Aleksandra, I'm a senior associate at Rymarz Zdort Maruta law firm, and I'm a technology lawyer that's specializing mostly, but not exclusively, in terms of copyrights, intellectual property, and IT contracts. And today, joining me today are the terrific experts of panels, so maybe you can share something about your experience and what you have done in the past in terms of license management or broadly in video game industries. So maybe Nav, we can start from my left.
So maybe I'll just start with an intro. So I've been working in the industry for about 26 years. I've worked in in-house roles, head of legal, general counsel, that kind of thing, but also externally in law firms, advising clients. So I've seen it from both sides, but also in management and licensing and development. So one of the roles I had was working for a game studio at Microsoft, helping them to manage that studio, which was the most interesting part of like the entire career, but also the most corporate. So there's lots of viewpoints that we can give, when we're talking about that. But I think what we'll do is we'll go through, I guess, everybody's intro, and then we can start talking about the details.
Okay. So once again, good morning, everybody. I'm still Francesco Rugeriis from Italy. Despite having held a jurisdictional and litigation panel a couple of hours ago, I'm most of the time a transactional lawyer and working on video games 30% of the time. So with that kind of experience, I'm here to share some thoughts. Thank you.
So good morning, everybody. My name is Petr Bratsky. I'm managing associate with Kinstellar, that is international law firm that is working across Central Eastern Europe. I specialize on IP and also data governance, and I'm kind of part of our also gaming task force, working with some of our video gaming clients. And now I will pass the mic to Riley.
Hi, I'm Riley Russell. I head up a small studio. We're an independent little developer. My studio consists of me and one other person. Before that, I did a little legal work at the PlayStation Group for 27 years, and before that, Sega. So I have a totally misspent career in video games. So hopefully I'll add something here, but I don't know what.
Thank you very much, guys. So we have this topic today, which is called license management in video games production cycle. And to be honest, this is like a really broad topic to be like talked about, because within your game industry, within your game company, you have so many various types of licenses to be used in. For example, license for music, like music put in your game, or like soundtracks, or like images, and so on and so on. And you can also have this license to use the software. So to maybe help us navigate during this discussion today and to make the discussion much more easier, I would propose to you to divide the categories of the license into the first category license that are used in the game. So this will be like all assets that the company purchases and put into the games. And the second category would be like all other kind of licenses, not necessarily put in the game, however needed to be like purchased in order to like run or operate the business. Like, for example, there's some tools to curate a game, like maybe some Maya software or Microsoft software, and so on and so on. So the first category I will like call it maybe like necessary licenses, as we like called it during our pre-meeting call. And the second one category will be the technical licenses. So my first question is, how should the video game company adopt a different approach, legal approach, to manage each of these type of licenses? So the first, necessary licenses and technical licenses, and maybe Nav, if you could start with that.
So if we talk about necessary licenses, say you're designing a video game featuring cars, and they're real world cars. So you would probably have to have a system where you want to work out which cars, and you work with the designers that they want, and each of those cars would have to be licensed from each of the car manufacturers. So that would be a process, first of all, on the design stage, where you'd get a list. And when I was in-house, we'd often sit down with the designers and we'd work out, what the car list was for a particular franchise. And following that list, the licensing team would be going out, discussing this with each of the car manufacturers, and then I'd be reviewing each of those agreements. And each of those agreements would be then logged, and then each of those agreements would have specific terms from a financial point of view, but also from the time. So how long is this license going to last? What are the renewal terms? And what do we do? So all of that information has to be then logged in a particular way, and in the old days it was just spreadsheets, but with new systems we can have flagging when expiry comes up and things like that. So that's just an example of, if you wanted to make a racing game and you needed particular cars, that would be a necessary license.
Somebody would like to add something to this? Maybe Petr? Yeah.
When you actually think about what you can acquire when we are speaking about licensing in the games, it's very important also, if, for example, if you are even external advisor or in-house lawyer, to know your law, to know the regional specifics, for example, because, for example, in my country, in the Czech Republic or in Slovakia, in this region where we are at the moment, for instance, apart from copyright, you've got also the sui generis right of the maker of the database. So, for instance, if you have IP assignment and you distribute it to your software developers, it is very important you have a clause, for instance, on this right of the maker of the database, and that it belongs to the video gaming company, because if you don't, then you can actually get in trouble. The same things like, and this is something that is very risky, and this is something what we discussed last night with Francesco, was the personality rights and the use of image in the game, the use of likeness. Because, for instance, under our law in the Czech Republic, if you get the consent of that particular person with the likeness, then that person can actually, by law, withdraw that consent later on. And I remember once I was getting a phone call from California very late in the evening. They were asking me, like, man, what the hell is that? Withdrawal of the consent. We are shooting a movie here. And I was like, yeah, but that's how it is. I'm just flagging the risk. And they were like, how is that possible? And I said, well, that's how it is, and it can actually get some trouble. Well, of course, I mean, if that person would withdraw that consent, that you can actually claim damages, for instance, for being it unreasonably withdrawn. But first thing, what is unreasonably withdrawn? And the second thing is, like, the dispute could escalate and could take a couple of times, and this could be quite difficult. So, as I wanted to say, you always have to know also about these risks and try to navigate them. So, for instance, with this case, we try to, or some lawyers in the Czech Republic try to circumvent it, and when we have these consent forms, we actually try to put their non-exclusive license in the broadest terms possible for this use of likeness. On the other hand, I think it's already some pending case in the court, and the court will likely rule that it is null and void, this license, because you cannot give a license for these personality rights. So even these things can be very tricky in terms of games development, and you have to be aware of that.
Yes, just to add something to the thoughts that Nav and Peter just raised, I think there is something you can think about this distinguishments that we just made. Like, for necessary licenses and for technical licenses, you have a different approach. One is from the in-house perspective and external counsel perspective. Of course, I'm talking from the external counsel perspective. I think that the necessary licenses could also be split again in game content licenses and game running licenses. Like, because if you're talking about the license for the game engine, for example, it's something you need to run the game. But it's not something like Microsoft Word or Teams, which is another license you need to work in a company, so it's more of a technical license. but you have to approach them differently because, for example, whilst in the case of these game running licenses, you have to approach them more like a technical one. So renewal terms, spreadsheet, having a dashboard on how everything can go smoothly. So it's more like of a contract lifecycle management. And then I think it's a very in-house things to do. This is something that some clients talk me about quite a lot, like having a clear view of what I have licensed so far, when it's going to be renewed. If I want to change something, do I have an exit fee, or what are the terms for litigation or something? Like have a very clear view. On the other hand, for game content licenses, you have where you most commonly might have the help of an external consultant. You need to have a very clear view of the perimeter of the licenses you need, which means you have done a very proper content clearance evaluation. So, for example, what happened once was a list of external assets someone wanted for his game, and that was happening, actually, it was a client of ours, and we had a very specific case which was very curious, which was they wanted to put some books of Sherlock Holmes in the games as part of a riddle to be solved in the game. So it was actually a very important part of a quest to be solved. Do we need something? Because Arthur Conan Doyle died quite a lot of time ago. But there was back then a situation where the first works of Conan Doyle were copyright free, but not the latest. So you had to depict Sherlock Holmes as it was in the, study you read, it was the first novels, rather than the last one, which is more reflective and more human, So you can also have a different depiction of a character inside of a game when you have an inbound license to be evaluated on a single element basis. So this is something extremely important to do. So I think this is the different approach you have to have, like more of a content reflective one for necessary content license and more of a management style for technical ones and necessary tech ones. I don't know if you really want to add something about that.
I don't know that I have that much to add other than in the process of clearing a game or thinking about a game when it's being made. Sometimes people think you need a license and you don't, and that's always the first analysis we always did over at Sony. Cars being a great example. Some games we licensed and sometimes we didn't. Guns, we never licensed guns, things like that. So there calculations you have to go through in setting up your game.
Yeah, exactly. Thank you very much. I agree with you guys about these different approaches, especially in terms that the in-games like licenses will be like laterally eventually commercialized, and this will be like the material aspect of your company, video game company. So you need to be more reflective of that. So we talked about some legal issues or like provisions that we should be like aware of during the negotiating license agreements, such as renewals, such as withdrawn, for example, or for example some fees. Do you have any other examples of such provisions or clauses that we should be aware of, or like negotiate or even push back to the licensor like during the negotiation?
Sure, we recently had a case, for example, and it looked like a minor issue, and it was within like video gaming transaction. We are on the sell side, and but the lawyers on the buy side, they found out that the database of our client for pictures or photos used in the game, that our client actually had a wrong license. They had a standard license with the terms. They said, hey, you've got this license, but it's for the development of projects up to $10,000, and some of these games were not up to $10,000, and we were asked those questions, and then we actually had to pick it up with that provider and kind of like ask for different license, which can get quite difficult, especially during the due diligence. It's quite embarrassing. The second thing, the problem is like, how are you going to approach that provider? Because when I was asking the client, they were like, okay, we've done it for a couple of years, already. So then probably the provider might get the idea that, they would be wanting some money they should have already had, etc. So it can get quite tricky.
Yes, I would also say that you have to be very careful about being specific of what you need, because, for example, in our jurisdiction in Italy, you have, for copyright licenses, for example, if you cannot just say, every exploitation rights. Now you have to tell at least something you want. So for example, if you want to use an asset for marketing purposes or merchandising ones, you have to be specific, because if you get the license to put an asset in the game, it doesn't mean that you have it to use it for merchandising purposes. And it's kind of like the Lucas film case where he actually got the money from merchandising, so it retained those kind of rights. So also be very careful about your strategy quite from ahead, which is a difficult thing to do when you're talking with business, because they might not know when you're asking them and when you're starting negotiating. But I think that could be a good starting point as an additional issue. And another one actually came out yesterday where we were talking, and because drinks help a lot in having more thoughts than you expected. AI elaboration. So, it's like, are we getting licenses to further elaborate the licensed assets with AI? Are we getting that, or should be more specific on that? Because if you don't get elaboration, you're going to have an exhaustion. It's very technical, but that's something new to think about when being licensed now.
Yeah, I'd like to add to that actually. So one of the things when you're, let's just say outsourcing, because it's not just a license as in there's a license as one agreement, but also you may get a license within a contract for something else. So outsourcing is always, it's often used in video games because you want somebody maybe to convert your game from one format to another, or you want someone to do some extra work, some extra engineering work. But what you've got to remember is that a lot of the developers that you work with, they usually keep some of their proprietary technology. So, so you're developing, let's just go back to the racing game example. You're working with a developer that has got its own racing tech, and they are using that when they're developing the outsourced product for you. You obviously are the publisher, and you're going to distribute this game across the world. So you want to make sure that not only do you own the product that they've got, but anything that they still keep, you've got a licensed rights for that to use within the distribution of that game. So when you compile the code, you can sell the game with that tech compiled within it. Also, what happens if you want to do a sequel? So does your license allow you to also then modify the tech that was theirs, as well as modify the rest of the game? So this is where it gets very, very specific and technical. When you're in-house, obviously you can sit down with the designers, the engineers, and get a lot of experience from them as to what they need. But this is the level of, I think this is where people miss a lot of things when it comes to licensing, because it isn't just, oh yeah, I'm just going to get a license off, I don't know, Maya or whatever it is. When you're working with other parties, you may be drafting licenses within your contracts.
And it's not just sequels, it could be just ports.
Yeah, and you may not have the rights to actually port then.
Yeah, exactly.
Yeah, exactly. So.
And now, another thing, it may come up 30 years later. You just don't know. Believe me, nobody thought these games would be replayed 30 years ago.
Well, that is happening because one of the clients I work with, we do look back at the old games to do remasters, and some of the stuff that it's a bit of detective work that has to be done, and sometimes you find that the way that games were made, how who they used, we've had to identify specific people. Not just a development team, but a contractor that had just come on board, and then get his rights just for his piece of work that he did, just so that we can remaster the game now.
Yeah, interesting. And after the negotiation part, we also may have jump into the implementation of the license into the organization. Because one thing is to negotiate the provision, the terms, and to know what a purpose of such license is, from the business perspective and so on. But then you have to implement those licenses within your organization or within your game. And such implementation is often made by people who was not a part of negotiation team, for example, and they may not be aware of the terms, specific terms, and, for example, the purposes. So, Riley, it's a question actually for you. As your internal perspective, for such many years, how the video games companies usually approach to this license implementation within the organization, if there is such a thing as implementation, or maybe how it should be, like, let's say, in ideal world.
Yeah, I don't know if we thought of it as implementation, and I was lucky enough to work for, a very big organization that had the resources, and so, this may not be the best answer. But what we did is the way I set it up early on, because originally anybody who walked in the door would like pick the lawyer they wanted, and that was a disaster, because one day we found out 4 of us were working on the same thing. And so we said, let's stop this. This doesn't make much sense. And we evolved. It was still on paper this time, but we would build a book of literally all the licenses that would appear in in a game. And I said, I want, because I'd been at Sony Pictures, and I went into their contract room, and for like 50 years you could just pull any movie out and find out every contract. And I thought, okay, that's what we need for us. And so that's what we started. What we did is we assigned a lawyer to every game. And the lawyer was not responsible for every license, but he was responsible for everything in the game. So maybe he was really good at doing licensing but didn't know privacy, so he would have to go to the privacy lawyer. Or there was somebody who had a specialty in copyright, and maybe if we're doing copyright, he'd go talk to but we made it so that the studio didn't have to figure out what licenses they needed. Somebody would sit down, they'd talk to them, find out what they needed. We'd have a discussion of whether we needed a license, what license we needed, what technology would go into the game. And then I insisted, that at the end of the game they produce the equivalent of a binder with everything in it. But that's, I also had more I had, 5 lawyers in the U.S. and another 5 in Europe, so we could do that. We had the ability. That was nice.
So you made a dedicated legal team for each game, which is very mature approach as for me.
We ultimately did a legal ops group just to keep track of everything because that's so large.
Exactly.
Can I just add something there?
Please,
so one of the things in a smaller organization, obviously you don't have the resources. You may be sole counsel, or you may not have no counsel. So an external lawyer may be helping you. But I think managing these licenses and any content that's within a game also comes up a lot when you're doing due diligence on an M&A. So, the buyer may not look at every single license, but there will be material licenses. So it's making sure that all of this is stored somewhere or easily accessible and catalogued in a way that when it comes to an M&A, that it can actually be found, so that we're not running around looking for. And these sort of practical things people forget, So in the early days, we used to have actual data rooms, and the company that I originally worked at, we were nearly sold 2 times. We nearly floated 1 time. There was lots of things we did. So we got really good at data rooms. We had drawers full of these are the contracts for this game. These are the but that's just because of all the experiences that we had, but it wasn't necessarily by design. But in hindsight, I think that's definitely the right approach.
I built a huge file room with moving file cabinets, and then of course everything went digital.
Yeah. And then it's all virtual data rooms.
And to add to Nav's point, also what's really important is even if you have a smaller company and you don't have the resources, at least with the very basic you need. Let's say with the licenses from the proper IP contributors, try to act as quickly as possible and make them to sign this IP assignment, because what can happen, and Nav couple minutes ago touched upon that, the very hard part is tracking them after a couple of years, because people leave the company, they go somewhere else. I was even discussing a story with one of the friends here 2 days ago that they had somebody who was designing some graphics for the video game, and the guy just left everything all of a sudden, decided to live in Amazon forest, and they had to chase him after a couple of years with some detectives in the rainforest, getting him sign this bloody IP assignment this in paper, not some DocuSign like these days. No. And this can get tricky, and when you've got due diligence and the gaming transactions, it can get very tricky because some of the people actually, because they try to take money out of it because they realize you need it for something.
Yeah.
And imagine you've got on the buy side, they will come with like 12 or 10 page IP assignment. Those people, some they don't want to sign it, some want to make money out of it. So then it can get difficult.
Yeah, we had also situations like that they just demanded like more money. But we also had like this situation where, for example, there was like IP contributor who was like providing some source code, and you know, source code is always living. You know, you like rewriting, and it may changed over the year. So we also like leave the company, the target, to decide whether it wants to, like, for example, sign a confirmatory deed because maybe the source code just changed a lot, so maybe there's no need or something like that. But I think that's not many cases. That most cases are literally where the people just contributed some IPs, left somewhere, and we cannot find them. And if we can find them, they want an additional money. Yeah, I totally agree with you. Yeah. Francesco.
So one of the reasons why Italy for that is very good land for developers is that by law, if you're an employee or an external consultant working on source codes or on other IP assets, it's of the company that actually hire you to do that. It's like a ex-lege work for hire situation, which is extremely good, but on the other hand, that's the law, and then what you can prove and you have evidence of. So you usually have something in the agreement written down. So we don't have an actual IP assignment, but we had to kind of chase people to have an acknowledgement of the fact that you were an employee working for me. So even though you have the law on your side, you might end up in the very same situation. So usually the best thing to do is like following Nav Sunner's approach, like do that from the beginning, being very ordinate and very coordinated on all the IP matters you have. Even internally with the employees, that's extremely helpful.
Yeah, so to set up like really proper organizational matters and so on, manners and so on. So this is like a common struggle actually for the video games company to like give contributors an agreement to sign or the license to sign and so on, and to organize it like in a proper manner. Do you see any struggles that video company entities have with the license management? Maybe Petr, if you can start with that.
Well, I see sometimes that the trouble are actually the resources and the money to do that, like the license management. Because, for example, I know about one of the gaming studios, well known in the Czech Republic, that they've got very nice tool for this digital asset management. It's one of the main ones. It's great. They can afford it, but then you've got the others who can't afford it, and then they basically end up with those like spreadsheets and papers. But it's not that organized.
I don't know if I agree with that. I had quite a big operation. I had multiple people, and I think it was probably more expensive going to digital than it was in the old days. And when I was at Sony Pictures, they had a librarian type person, and she was great. She could find anything from 50 years ago, and it was all on paper. And so it's really nice to have the digital contracts management system that keeps everything, because at least you got the continuity. But if you had someone who stayed there 50 years and had a pencil and a good spreadsheet, you can pretty much do it. An Excel spreadsheet is a wonderful thing sometimes.
I can add to that, I think. So that's actually a really interesting point about who actually manages these licenses. Who do you point? And going back to what you were saying about this librarian type person, when I first joined the industry, the PA that used to be for the CEO of the company, she was actually somebody who, I've never met anyone since then who knew so much about video games. She would, back in the old days, we used to have helplines, hint lines for people, cheat codes, these things. People would ring in. This is in the sort of 80s and 90s, and she did that job. She'd done. The receptionist job. She'd done all these jobs within the games company and learned basically how a games company works. And then being a PA, she knew about every contract. Every contract that came in, she knew where it was filed. but that kind of knowledge, no one does that anymore. So
Yeah.
I
And
know
when she
what
goes
you're
away,
saying.
you're in trouble. We had, when I started, and this is why I ultimately made it an actual part of the department, just to handle this thing. We had this wonderful woman who knew where everything was, but she had the most obscure or couldn't understand her filing system, because she sometimes filed by the company name, but sometimes she filed by what the license was about, or and only she could find things. And when she left, it was a disaster, you know. So no.
But the other thing was, and
You got to set up a process. Is what it
yeah,
amounts to.
they were like they're like really old games. So because so Codemasters obviously has been around for many years. So before I even came to the company, there were contracts done, in the late 80s, sort of mid 80s, late 80s, but they were in the attic, like they were in some room, because they were not going to come out. But actually, when we were looking at the tail end of games, IPs from the past, suddenly it becomes relevant. Let's check these, who owns which rights. But only she knew where those contracts were. So this is the kind of thing that, I guess now that things are digital, but you can't touch them. Like, it's not like, oh, there's that box. In the digital world, it's everything's the same. So I think markers or labeling, I think, it's become even more important. And doing it by game actually is the best. Because that game has got all of these things, these are the contracts, I've found has always been the best way.
Well, just not to add about some these practical tips, because I think I couldn't add anything about that, but for license management, at least in European Union, we kind of have a elephant in the room, which is the transparency obligation set out by Article 19 of the Copyright Directive. So when you got assigned IP rights from artist and executor, and in Italy that also involves voice actors or voice acting and dubbers, organizers, these kind of things, they have some rights for a fair remuneration. So pursuant to the directive and in its implementation in Italy, you have some transparency obligation. You have to tell them how much you are actually making from the product that includes that work. And they have the right to claim fair remuneration if it's not enough what they got from the very beginning. And this is very problematic, because the first solution everybody thought about was like, let's have a full buyout from this stuff. Just hire them and pay everything once. The directive said, no, you can't, because if you did that, you might actually end up have to add more money. So now what we are having is a situation where we have no more lump sum payments and full buyouts, but like kind of a royalty, not a revenue share, rather a royalty, because you are actually getting all the rights if you are actually getting them assigned rather than licensed. But then you have to share proportionally to what you're making, and that's actually helping. So having a very coordinated and ordinated system about the agreements is also about the revenue you are getting from that agreements and that video games you're making, because that helps you complying with these elements of the law that actually have fines. It's 1% of the turnover of the company. So this is kind of a big deal that nobody's actually carrying now. It's like, okay, we know it's there, just look the other way around. In Italy, we have only one case law. It's about the Italian Collective Society and Meta, but there was more about antitrust matters and included that. And it doesn't involve coders, so that's not a problem for source codes, but for artists, voice actors, and everybody else, this is becoming something to be aware of, I think, just to terrify people a bit.
Petr, would you add something to that? Because
Yeah, sure. About these transparency obligations, I would like to ask you guys if you actually came to some interesting cases, because I had one very recently, and one person was claiming this fair remuneration and actually claimed under this transparency obligation lots of documents from the company. But I was kind of, the transparency obligation under this directive and under what was transposed into Czech law, for example, it is very broad, and I was kind of afraid that I would be, as a lawyer, advising this company giving out actually too much, because it can be know-how, it can be your records, secrets, you know. What do you think? Because I was afraid about that.
I think I'm going to avoid the jurisdictions. Honestly, I don't want to deal with that.
That's the solution everybody's having. Like, okay, let's try not to do that.
Yeah, no, this is a really interesting point, because music as well. comes into this, and you end up with forum shopping because where why would you go to a jurisdiction and use a musician who's part of a collecting society, or you can't actually get a buyout? You would go to the US instead, because in the US you can do these things, and the same with these, with that directive, in terms of extra remuneration post a contract. Why would you go and deal with someone where that law applies? I mean, so it's causing a bit of problems there, I think, because it will then take away, I guess, jobs from places where so. And the legislators, they don't always think about this, but when video games are so worldwide, and we can get resources from lots of different places in the world, so it's counterproductive in that sense. So yeah, going to Riley's point, you just avoid it, so why would you have this transparency obligation then? Why make yourself?
One of the reasons I think that happened was that because the lobby that actually pushed for that kind of legislation was the cinema industry inside the single European countries, where actors and other kind of figures and executors actually had this issue of not being fairly remunerated, but then they got it broad, and it applies to video games too, which is a way more international industry, and that actually raised a situation of, okay, just not go there. I'm not going to hire a European musician if I have to face that kind of thing. I just have a full buyout everywhere else in the world, and that's not the purpose of helping actually the artists.
Yeah, exactly. I have like a similar point of view on that. Actually, a couple of years ago, we had like this, for example, really well-known like claim from Andrzej Sapkowski, if you recall, to The Witcher.
We heard about it.
Yeah, about it's loosely relates to the clause, bestseller clause in our copyright law, when it's a gross disproportion between the revenue from maybe not the original, but the other work which was inspired by the original work. The author may file a claim for additional money. So I'm not sure how it ended. I think there was like a settlement here. Yeah, settlement. Yeah.
Of course.
Yeah, exactly. So this can be also the struggle. However, I mean, in Poland, in Polish copyright law, you have this transparency obligation when you set the revenue remuneration in the contract, in the agreement. So yeah. So maybe we can jump to another maybe issue regarding the disputes in terms of license management. Because I think this also we should adopt a different approach to this necessary license, because the dispute over such license which are used in the game as a material aspect of a company, might kind of be really painful for the company, because the game, for example, might be taken down or banned, or I don't know, something else will happen on claim infringements will be made against the company. And as in terms of technical license, I believe that it's more it's not a thing that's let's say as a rule will kill your business, So as a lawyers, how would you prepare a client for a dispute of such in terms of necessary and technical license? And maybe, please, Riley, if you could start with that.
I'm a little lost on the question. So the question is...
how to prepare to legal dispute with a licensor in terms of the license management?
In terms of the license, and we're anticipating a legal dispute.
Yeah.
Well, the first thing you do is pick up the phone and you phone the other side and try and find out if you can resolve it, because there's no piece of litigation that's really worth going through. But every once in a while you have to, and you do it. And if you're lucky enough to, I can't really remember too many in my entire career, and I've litigated a lot. I can't remember too many disputes that we actually went into court where we had a license that that dictated. We would always put in arbitration clauses in if we could, or we would put things in it. But the reality is most of the time we went in, there wasn't an underlying contract. What we would try to do, and I actually now build into agreements that I write, Not only do I put an arbitration clause in, before they can even go to arbitration, I require the CEOs to talk to each other. Now, whether that's enforceable or not, I don't know, but I put it in there, and it to me, it sends a message to both companies. Look, we want to work this thing out. We want to resolve this, as opposed to litigate, no matter what happens. But I don't know if that answers the question or not. But avoid it. Avoid the litigation.
I can add something there. So, I think when you're designing games, you're putting in content. Sometimes what you do end up having is, if you have got lots of licenses, and I mean, everyone's probably familiar with the word texture, because texture obviously is the content of putting it on the skin of a 3D shape or whatever it is. Those textures, how can they be easily removed? So if there is a dispute, can you switch it? So there's lots of practical things in terms of particularly when you're thinking, do we need a license? Because that question always comes up. And it may be that you did, but you made a calculated risk thinking, well, we didn't. But sometimes you do get situations where the license has expired, but someone has forgotten to renew it, or there's a situation where you thought you had perpetual rights, but actually you didn't, because of the way that, or maybe it catalogued it wrongly. Someone had put that in, just the way it was listed. It's like, 4 or 5 years go by, and actually the license had expired, and you're just carrying on. But it could be that if you keep paying royalties, you can carry on. So going back to Riley's point, you could have carrying on paying the money and just having a renewal, because if people talk to each other and go, well, actually no harm was done, then there's no issue. So I guess there's abilities of making sure that when the game is designed, that you can react to a dispute, and and that may not always be possible, particularly if it's the tech. So when you go back to like distinguishing, if it's the whole engine, then you're in trouble, right? But if it's textures, if it's things which are cosmetic that you can just remove, replace, revise, and particularly now, not like the old days when we had to recall discs. I don't know if anyone has ever done that, but I've been in situations where that has happened. But that doesn't have to happen now, because we have mainly people are going towards the digital distribution, so you can change things with patches.
I agree with that approach, because, for example, recently we had a case with a video gaming company and the use of the fonts, because we got a pre-litigation notice by the company that is the graphic studio that is producing the fonts, that they use it in the game, and we are like, oh my god, what are we gonna do? And first thing that came to my mind was like, hey, I'm just gonna send them the letter that it's not the truth. But then I look at the attachments, and they had actually tangible evidence with the metadata that we actually used it. The best thing what we did, and that's what Nav said, Riley said, we picked up the phone. We tried to settle, we tried to negotiate with them, and at the end we actually got a new license agreement with favorable terms for quite a long time. So I mean, it was kind of even cost effective for the client, because it was a longer duration and for a reasonable amount of money.
But to go back to what Nav said, there has been times where the game's about ready to ship, and you're like, okay, 2 questions. One, if we ship it, will we get enjoined? And if we're not going to get enjoined, can we patch it? Or if we're going to get it, can we patch it? And if the answer is yes, maybe you take the chance.
Yes, that's absolutely very true about the difference with digital and physical distribution. Well, on the other hand, something I usually suggest is being ready to audits, which are actually, because it's licensors we are facing here. So we already thought there was a license, we actually executed one. So how can I be ready to fight in case that happens? And of course, the first thing is try to avoid that. But for example, one of the leverage that we saw happening more often was that licensor actually enforcing his audit rights. So sending you a notice 5, 3, 2, 10 days before, say, hey, I'm coming here with Ernst Young or PwC or whoever, I want to see your books and records and see that. So be ready for that. That's always something I tell them, that don't forget to register everything properly, because that's the first thing. If you're doing everything good, or if there is a small shortfall, that's okay, but you can actually have them pay for the audits, and that's what means that what they think you did wrong was actually a cost center for them, and actually put you in a stronger position. The second thing, that more for trademarks licenses is like respect the guidelines and gather evidence that you did. Like if you have a trademark, this happens a lot in Italy with fashion, of course. When you have some fashion elements inside a game, one of the example I can get was the Vivienne Westwood in Final Fantasy 15. There was a quest about a bridal dress, and there was actually a quest with the Vivienne Westwood trademark there. So you can have something like that, or we can think of Louis Vuitton for League of Legends or whatever. So we have these two big words that are starting to mingle a bit. But fashion lawyers, I don't know if you ever had the chance to meet these lovely people, are not like gaming lawyers. So they are very strict about every single inch or centimeter, if you prefer, how you use their trademark, or even the nuances of the colors. So you have to be very careful about the use of Pantones and these kind of things. One of the best thing that you can do is talk directly with the artistic and the artistic director of the team and say, hey, when you use these assets, please just prepare some sheets about how you respect those guidelines. And then you send them beforehand. And that just calms things down, and the IP counsel of the fashion company is really very happy because he can go to his general counsel and say, hey, see, we are making money out of this industry, we are going to the Gen Z and these kind of things. And in Italy, this is coming actually it's becoming very important because we have a lot of fashion elements, especially in Milan, and they often do not know how to talk with gaming industries and gaming industry lawyers. So we are kind of the nexus of translating these two elements. So this is a suggestion I would give.
Yeah, terrific. Thank you very much. That was insightful. Last thing I would like to talk about is like maybe like legal tips on lowering the cost of licenses. And following this up, there was a couple of years ago, there was like this Usoft ruling that the ACJ gave about in the case between Oracle and Usoft, the German company, who was acquiring licenses from Oracle and then reselling them to the end users, other end users. And actually, ACG state that the resale of such software is generally permitted within the European Union. However, under some of circumstances, legal conditions, which are like this software needs to be like put into the market on EEA. Secondly, this need to be like a perpetual licenses. The right holder needs to like get the reasonable remuneration, and so on and so on. So, do you see any chances to implement use of ruling in video game industry?
I don't, and the reason is that this is extremely important for technical licenses or for game running licenses, which they just simply changed their business model. So I do remember being a European lawyer telling to Americans, guys, perpetual licenses are a big problem, because if I'm granting you a perpetual right to do something in exchange, for example, of a lump sum money for a code and use it for perpetual time, that's a sale. And that's a problem, because that probably will exhaust your right. No, that's never going to happen. Of course it happened. And so the problem is that, okay, how can we face it? Just shift to a subscription model of yearly renewal licenses. So in that case, you cannot have a lowering about the purchase of used software. That just, you go back to the first thing we spoke about. It's like, how can I renew? Do I have an exit fee? And how I manage this kind of recurring licenses I need? But so far, I would not see room for a used software market for the development of video games. I rather see a most competitive market of subscription model and software as a service situation. I don't know if you guys agree with that.
So, yes, an interesting point. I mean, when we have, so again, going back to the past, we had obviously cartridges and discs and things like that. So that then those things themselves, once they're on the market, they're effectively exhausted, because that's goods. But the software inside, remember, these are all basic principles from a legal point of view. That's licensed to you, and we have that's why we're end user license agreement. That's what it means. You're the end user. It's licensed to you. But this is a very challenging thing, in terms of, and when you sometimes do an asset, like when you acquire assets from a company, you might buy the Maya, but are you able to transfer it? And then the terms of the license probably say, no, you can't. But people just do it. This happens, and as long as Maya's being paid, if it's a recurring license, they're not going to care. So I guess the point is, but if it's a one-off transaction, I don't know what the answer is. And I think what you're saying is no, but there are many perpetual license in video games on purpose, because you don't want to keep renewing, you don't want to keep going back. So what's going to happen? Is there class action claims coming, or, no one's ever challenged it, from my experience. I don't know whether, Riley, you've got anything.
Well, in the consumer space, there's always kind of a rumbling about can I exchange my digital assets, right? Even though the license agreement may say you can't. But
I think
at the development level, everybody wants to do business, so I don't think they, at least not the people I worked for, they weren't going to come after.
Well, you're supposed to, just going back to some of the terms of the EULAs, you have to delete all of your contents.
Yeah.
And then you've got, there's these steps, and so you do all of these things, and if you put that in there, you can transfer the actual software. But who does that?
Nobody does that.
That's why I say no.
Yeah, and actually the licensing models are also changing. That as you, like you spoke earlier, Francesco. I mean, earlier, like we had some perpetual companies that sold perpetual licenses, but companies changing that model to like subscription to cloud computing or something like that. So, or maybe some hybrid models, So I agree, and I don't think that use of model, with some exceptions. For example, I still believe that Microsoft Offices might be like resold. However, what is the license here for game companies? I mean, it's not as crucial as other ones, So I actually agree with you. And Riley, is there any resale market of software in the US, or is something like?
Well, there was up until everything went digital and you bought it on the store, because then they couldn't get a hold of it. But if it's not pressed on anything, yes, there's a resale market.
One problem with the subscription and recurring thing is the legacy effect. Because we have dark partners in video games, where we have dark partners in technical licenses too sometimes. So it's hard to get out, and so you have to be very careful about how you choose some technical elements you're going to use, I think. And of course, this is a technical evaluation, not more than a legal one, but it should be something that you think about it. But I'm old enough to remember on-site and on-premise licenses and perpetual ones.
Yeah, exactly. So actually, we have like 7 minutes left, yeah? So maybe any of you guys have any questions?
Is it working? Yeah. Hi guys, Kuba Jankowski from CD Projekt Red. Thank you very much for the super interesting panel, and thank you for the Sapkowski case flashbacks.
Sorry for that.
No worries. I wanted to ask you specifically about license management in regards to assets bought off of marketplaces, like readily available assets that you can put in your game. I'm talking about 3D models, I'm talking about animations, and my personal favorite fonts. And so they are, in my experience, quite tricky, right? Because they don't really come with license. You just accept terms of service that are there, or EULAs that are there on the website. And one thing that you might get is maybe an invoice, right? So in my experience, it's quite difficult to archive them and to keep them around. And you need to do that because, well, eventually if someone comes after you, you need to prove that you bought a certain asset. So my first question is whether you have any practical tips and tricks in regards on how to do this. And my second part of the question is, do you actually know or experienced any case of the marketplaces actively going after people and checking whether they actually have a license? Because I haven't, but I want to hear whether you did.
Really good question, actually. In-house and also externally, I get a lot of these questions of, all these marketplaces are out there, people want to use these 3D assets. The first question is always, what are the terms? I've actually managed to sometimes get an agreement, an actual written agreement, outside that license to refer to certain terms, because sometimes those terms are so bad, I wouldn't recommend signing them, right? So, recently, because I've been working with some very experienced, veteran developers who've set up studios, they're very good at saying, look, let's get this checked. And they're good at setting up a central tech sort of department that can manage these things. But that's kind of what you should be doing. You should have tech people basically looking at these. The lawyers obviously have to review these terms, making sure that the terms are correct. And what is the sort of the implications if something goes wrong. Font licensing, whatever you do, make sure you get your font licenses, because they will come after you. Yeah. Adobe will come after you. I don't know if there's anyone from Adobe here, but...
Or make your own fonts, that's,
As long as they don't look the same. But, that kind of thing, I mean, the font licensing has always come up.
Yes.
And there has been... but on the 3D modeling, I mean, if you look at some of those stores, I'm not going to name any specific one, but sometimes they act like a marketplace where other people are putting stuff on. And you really think that some of that stuff is, original? You know what I mean?
Yeah.
So you have to make a calculated guess.
Yeah, there was a case last year, I believe. The game was called Bleak Fate, and basically it was like 4 developers from Bulgaria. And I know that they took something from the marketplace, like an animation for a boss, because it was a Souls-like. And it turned out that the animation was ripped from one of the Souls games. So, yeah, that happens.
Yes, absolutely. About the fonts, I would give the same advice. In Italy, in this couple of years, this is one of the most challenging things we're facing. 2 things. One of the practical elements on how to archive this kind of situation, because not everybody is a superhero like Nav that can actually get a license talking to people, because Italian developers don't have Nav, so they have me, so they don't. But no, wait, just kidding. One thing you can do is, usually when you subscribe this kind of elements, you receive an email. It's a very, very cheap trick, but you receive an email. Archive the email about when you purchased that, and print out, with evidence of the date, the current terms and conditions applicable. Because it's not sure that you can have the actual ones that would have ruled what you downloaded at that moment. How can you archive them? Well, in Italy we can have a registered email, which has a timestamp. Or for the most technical people, you can have blockchain-based archive system, which are very cheap actually now. So you can have the TNC that regulated your download in that moment. They are shitty TNCs, but at least you know what you're fighting about. Even though you adjust the notice, usually there is a link or something, so there's something you can do. So apart from fonts and this kind of situation, something I would suggest is to keep in mind that you can have most convenient work for hired people, like Riley was suggesting, for fonts and this kind of elements. And the last thing, a case that actually we have was for a GTA server run by players. And it's fun because there you have absolutely perfectly clearly counterfeiters stating that this is absolutely original work from Rockstar Games. No worries, you can use my Ferrari model here. There's no problem at all. There is no copyright infringement. And then you have the TNCs of the shop saying, we take no responsibility about everything you bought here. It's like, okay, guys, so just to be clear, don't do that. So be careful where you're purchasing stuff.
Yeah, thank you very much, guys.
Welcome.
First here. Hi, Tadeusz from One More Level. Actually, a little bit between those 2 questions. Perpetual license and the subscription model. The problem is if you are purchasing something in the subscription model, the terms can change in 1 year, in 2 years, in 3 years. And we as a developer actually first don't worry about this, but yes, we started to worry about this. But the problem is, for us as a developer, changing the license for subscription license is sometimes very difficult to follow up, because sometimes resources are not enough for developer to have a big lawyers here. And how do you think we have to approach checking every day if the license hasn't changed or something like this? Any advice here? Thank you.
This is I mean, it's a tough question. I mean, I guess remember the other thing you got to think about is, what is this license for? So the license, if it's helping you build things, and you need, because remember, if the license is something that is part of like some engine, what you're paying for when you're renewing it is the updates and the support. But if it's something else, which is just a tool that you've just used and you're never going to use again, it's like, so I guess you've got to make a choice as to which of these things is more important than others that you've got to track. Because you can't, if you have got limited resources, how are you going to track everything? And that's really what this is about. Or do you have one of your engineers assigned to this role that they've just got to keep an eye out? But when does it get triggered? It's like all of that would have to be checked. But in larger companies, you can have people dedicated to looking at what's coming up, and that's usually from a central tech team.
Maybe how about also using some kind of different tool, or thinking about like some of the free libraries, free tools, open source software instead of the subscription model. Of course, it can get tricky. On the other hand, if it's something that it's, as we said before, more technical, try to also get some of these even technical people, see what you actually use it for, what you actually need it for. And if it's something just technical that you don't need it necessarily, as Nav said now, maybe you can observe some of these free tools, but make sure you, of course, read the terms as we said before and see that the license is permissive.
Yeah. Plus, this might be this might come as a shock. Read emails, guys, because usually when terms and conditions changes, you get notified about that change. So, and at least in Italy, what actually happens is a kind of an extensive interpretation of law, is when I notify you, I give you a couple of weeks in which you can withdraw or accept the new ones that will apply as after 2 weeks. So don't just consider all those kind of email spam. I know it's hard sometimes because they are like coming to the same, from the same emails where you receive marketing updates or the kind of things. So what I usually suggest is to have one email specifically dedicated to subscriptions for all the technical licenses. So you have a guy from the technical department or whatever, should be kind of a contract manager, but it's not, that actually sees everything. So he knows if something happens. Then, of course, the subscription model gives a lot of power to these guys, because if you need them, how can you change? Just to not make names, but Unity some months ago in October, we remember what it did, what it happened. They wanted to change the paradigm to a runtime model. It was really an earthquake in old gaming industry. We discussed a lot about it, but that's actually one of the cases where you can see the community power, because if everybody started complaining, so it's not actually a class action or something, but you have publishers starting inserting in the agreements in November 2023 no Unity clauses for development of mobile games, which is more than half of the market. Then Unity has to back off and change the bit, so no more retroactive and everything, and exactly what happened. And not in the gaming industry, something very similar happened with Hasbro and Dungeons & Dragons open licenses. So we are actually seeing that these open licenses or subscription models can actually have some shortfalls, which is the power of how many people are actually using them. So they have to build trust with the community. Of course, they still have the power. Of course, they still can change. But we can move a bit more together as an industry. But of course, if you are PlayStation, you have a different negotiation power. That's another issue.
Yeah. I can't, no, I'm not PlayStation, so I can't comment on that.
Yeah. was a casual reference.
Yeah.
Unfortunately, we don't have any more time, and we need to start next.
Reach out afterwards.
But there is a question for you, waiting for you outside. Please refer to it. And thank you very much for everyone. It's an interesting panel.
Thank you.
Catch the speaker. Thank you.